Welcome to A Taste of Justice. I'm Professor Angela May Kupenda. For informational purposes only, I'm a professor of law at Mississippi College School of Law, but all interpretations here are my own and are not to be ascribed to my school or to my students. Let's get right to it. I've been having a fantastic time with my students. After taking their examination, just a little 15-page examination, they worked on constitutional position statements where they examined a current constitutional conflict and argued the position different from their own, then argued their own position and sought a resolution. There are many, many constitutional debates and constitutional conflicts that we're facing as a nation. So what they've been doing is 10-minute presentations each of their position statement, followed by some questioning. And they're doing an excellent job. This is the third class meeting I'm reporting on back to you. I'm summarizing their positions. I'm not going to use their names, although I'm so greatly impressed. I'm going to do my best not to use their names for their personal privacy. But they're doing a great job. And whether I agree or disagree with their positions is not really relevant to me as their professor. My role as their professor is to help them to analyze and support their position, but also to analyze and give due deference to the position that is competing with theirs, or different from theirs. And for us to learn as a class of students, with myself as the professor, that we can disagree. Our views can be different. We can disagree, but still hold each other in great respect and treat each other with professionalism. That's also something we're working on in the classroom. So at the bottom of this video, you will see the titles of the 7 positions that my students presented actually in class on today. And so I don't have the full statement for you to read, but I'm going to briefly summarize each position. And you can think about and debate and argue with your family and friends as to which positions they endorse and which ones they do not endorse. And the same is to yourself. But I'm going to summarize their positions and then tell you a little bit about what else I asked them to do. Of course, we don't have enough time in class for me to ask them all of my questions. So after the class is over, I send out the group of students who presented an email with a number of follow-up questions and give them a few days to think about them and then to address each question I pose. So let's get right to it. So the first student's position statement said, the governor's lockdown for the state of Mississippi was lawful and did not violate any constitutional rights. That was his position. So the law school is in Mississippi, and that's why one reason why he was looking at the Mississippi lockdown. Now, his view turns on what is the level of scrutiny you will give to governmental action. If you go back and look at an earlier clip I did, what you're talking about government, it talks about where the government should be evaluated under a very low standard, or where the government should be evaluated under a very high level of review. Ordinarily, the court says that we evaluate government under a low level. It just has to be rational. It does not have to be smart or wise or the best. But under a heightened level, we scrutinize government more. The heightened level is reserved when government has infringed on fundamental rights or where suspect classifications are at issue. The highest level is called strict scrutiny. You're strictly scrutinizing what government has done. And the lower level, the lowest level, is called rational basis. It doesn't have to be wise or smart. It just has to be rationally related to a legitimate governmental interest. So in his position statement, he says that what the governor did in Mississippi certainly met the low level of review, rational basis. And so therefore, the shutdown was a constitutional act by the governor. Now, I had some follow-up questions for him, a whole lot of them. I asked him, what would the government have to have done? What could the governor have done that would have made him say that what the governor did was irrational, right? Or is the level so low that almost anything the governor would have done would have passed the test? You see, the standard of review is going to be very important in the lawsuits that are coming and that will likely come, argued against the governmental shutdowns of businesses or stay-at-home orders or what have you. And so under this rational basis test, it's a low level of review. And likely government meets that test unless the court determines it should be a heightened level of review. He did a wonderful job. I sent him some fascinating questions. We'll have to see what his responses are. The second student's position statement, and again, they're all at the bottom of the page in the type, was this: state restrictions on abortions during COVID-19 are unconstitutional as the restrictions place an undue burden on a woman's right to choose an abortion. This student also did a wonderful job. His presentation was similar, but also dissimilar from a presentation addressing abortion rights during the pandemic that is discussed in the previous clip. So he argues that the abortion restrictions were not a valid use because they placed an undue burden on a woman's right to choose an abortion. And so he gave a couple of situations in terms of what happened to some women who were unable to get an abortion because of the governmental shutdown. And in at least one instance, one of the women ended up in a hospital as a result of some abortion pills she had used. So here he's saying that when you look at how time sensitive it is in having an abortion, and that the court has recognized it as a fundamental right, that the government's shutdowns and restrictions of abortions, even though it was for a limited amount of time, he viewed it as an unconstitutional act by the government. Now, I had some follow-up questions for him too. He did a very good job explaining the various levels of review and explaining the history of abortion rights in this country and what have you. But one question I have for him was, what if a restriction during COVID affected abortion, but the restriction had an exception for to allow an abortion where the woman's life was at stake or where her health where failing to get the abortion could cause substantial harm to her health. I asked him, would those two exceptions be enough to render a restriction that he believes to be invalid to make it valid? And I can't wait to hear what his response is as to those questions. And like I said, they both did a wonderful job. The third position statement was this. The student said, restricting travel of US citizens between states during the pandemic is constitutional. Now, the student acknowledges that there are provisions in the Constitution to protect one's right to travel. Article 4, also state privileges and immunities to unite us all as one country. But here, the student said that these restrictions, however, were constitutional when you look at what was at stake. She said that her preferred view would have been that we had one uniform law that applied to all of the states. So therefore, if you're traveling, you would know what the rules are as you set out on a road trip or traveling some other means across the country. Now, I had some questions for her too. She did a very good job. She said that, and I want to make sure I'm paraphrasing her correct, the right to travel should only be restricted by one uniform law, that there should have been one uniform law applied to all the states in the same way. So the question I posed to her is, if during the pandemic, if we come up with one uniform law, if there is one uniform federal law that indicates traveling from one state to another, is there a quarantine period, who can travel from one state to the other, and what have you. How would that law, what would that law look like? Would that law be based on the situation that is happening where there are the most infections? Would the law be based on the situation where there is the least infections, or on some average? And so how would that play out in shaping one uniform law? In one sense, it does allow us to be one nation, right? And the right to travel, that's why that is so important. But on the other hand, what would be the nuances of that law? And that's one of the questions I posed to her, as it may be a question that we find ourselves considering in the very near future. And again, she did a great job analyzing those very difficult issues. Now, my next student let me read this one. My fourth one says, our Constitution recognizes a fundamental right to travel. And while this right can be limited by state restrictions created to protect public health and safety during the pandemic, these restrictions must be assessed under strict scrutiny. They cannot be overly broad, and they should not treat residents unequally based on classification of citizenship. Now, when I read her position statement, I'm like, okay, is she saying that the restrictions on travel were lawful and constitutional, or is she saying that they were not? So I pushed her a bit on this in class, exactly what is her position. And she framed it very well. Her response is that based on the Constitution and the law, she believes that these restrictions are indeed lawful and constitutional. However, she put in that however, she said they are suspect. So she's going to say they're constitutional, but she's going to say they're suspect too, that they are not the best way of handling things. And they need to be monitored very, very carefully, lest they step outside. So she thinks they're somewhat on the line of being constitutional or not. She's going to say constitutional, but she believes that they are highly suspect. And I also framed some questions for her to consider, similar to the questions I framed for the other student who was writing about the fundamental right to travel. And she did a great job too. Now you probably say, I'm saying they all did a great job. I am telling you the truth. They did. I was so proud of them. They've taken that exam and now they've grown and they're doing a deeper look at the law and the Constitution. Learning about the Constitution is critical, right? We the people, we want to ensure more justice, or at least a taste of justice. Learning leads to enlightenment. And I'm so proud of my students, of the way they're looking at these issues and the way they're engaging each other when they can stop me from asking questions so they can indeed engage with one another. Okay, let's go to the next one. I think we've done 4 now. I'm down to the 5th one. The student's position is this: mask on, mask off. Even during a pandemic, the president does not have the authority to implement a nationwide mask mandate based on executive power alone. So here, you're probably thinking, I had not heard that President Trump was getting ready to do a nationwide mask mandate. Well, this student's position statement is looking at a statement that, a position that some say that Vice President Biden had, that a nationwide mask mandate could take place under executive power of the office of president. Now, he says that he made that statement or that implication. I'm not fully aware of that, but let's just say for argument's sake, the question is, could a president use the executive power of the office of president to require a nationwide mask mandate? Now, the student's probably going to say, Professor Kupenda, read the sources I gave you, and you'll see that I was right on that, and probably so. But right now, we will just make it a hypothetical-like question. So the student looked at a case that we talked about in an earlier clip dealing with presidential powers. And in that clip, we looked at a case called the steel seizure cases, where the president attempted to take over the steel industry during when we were at war. And the court said that the president could not do that. And even more important than the majority opinion saying the president could not do that, there was a concurring opinion by Justice Jackson, where he talked about the 3 tiers of presidential authority, that the president has more authority when the president is acting with the express or implicit approval of Congress. The president has least constitutional authority when he acts against the will of Congress. And there's somewhere in the middle they call the twilight zone, where it's not really clear which one has the authority. So in his statement, he framed it very well in that he's asking, could the president do this alone? Could the president enact, or could the president by executive order have a nationwide mask mandate without the cooperation or the express approval or implicit approval of Congress? And his argument was that the president could not do this, that it would not be within the president's authority. Now, I pitched back to him in my questions a little hypothetical. I said, what if in the coming months, a president had a nationwide mask mandate? And what if Congress was totally silent, just totally silent? And what if most of the governors agreed? They wanted some uniformity as opposed to the governor having to do this by executive order, her or himself. Would that change his view as to whether it would be constitutional or not? And as to what tier of those three levels of authority of the president it would fall within? And I'm waiting to hear back his response to that question. Now, by now you're saying, none of this is straightforward. Why are we sending these people to law school? There are not solid answers. And you're their professor, give us the answer. Well, we have the Constitution and we have interpretations of the Constitution. And when we're faced with new questions, we have to look at the precedent, the authority, precedent, P-R-E-C-E-D-E-N-T. I was not referring to the president of the United States, but we look at what precedent, meaning what rulings the court has given before, and we try to apply them to this new situation. And so in a new situation, we may say, this is probably constitutional. It is probably not constitutional, but we really don't know. We really don't know until the matter goes all the way through the courts. And then sometimes we still don't quite know what the full ruling is on the matter, because the court may leave some things open. So what I'm trying to show you is how we discussed and argue, and the kinds of things you may be hearing about in the news and what have you, as these cases are likely going to be going through the courts in terms of how they're going to look at these issues. Okay, so let's go on to the next student statement. The student statement said, student position, President Trump can't withhold federal funds from schools who refuse to open during the pandemic. So we had one position statement focusing in on Vice President Biden, and we have another position statement looking at President Trump. And in her position statement, she refers to some of the things that President Trump reportedly said when he wanted the schools to open in the fall. Her argument is that the president cannot withhold federal funds, which is one of the comments that was apparently made, that federal funds would be withheld from schools who refused to open during the pandemic. She said that coercion, she said that's presidential coercion, and that presidential coercion is unconstitutional. She said the president can encourage states, the president can encourage school districts, but her argument is the president cannot coerce. You see, there's a case called South Dakota versus Doe, and it deals with Congress using the taxing and spending power to encourage states to do certain things, but not to coerce states to do certain things. So I said there's some questions too. I'm wondering if presidential coercion is worse constitutionally than congressional coercion, or the reverse. You know, we also had this case called Shelley versus Kramer, where the court said that if the judiciary places its stamp or its enforcement power on racially restrictive covenants, it is using the power of coercion. It is acting, and therefore it is violating constitutional rights. So her statement really poses some fascinating issues about how far can the president go in placing pressure? How far can Congress go in placing pressure? And which, let's assume that they are both coercive in what they're doing, which is worst to the Constitution? We want the Constitution to survive, right? So which causes more harm, for Congress to coerce, or for the president to coerce, or for the judiciary to coerce? And those were in the questions that I sent to her. And again, she did a wonderful job too. Our final presentation for today really closed today with some very thoughtful comments from the student. The student's position statement is as follows: the federal government, using its power under the Taxing and Spending Clause to strongly encourage states to mandate a COVID-19 vaccine on citizens, is constitutional. So this goes back to what I just said about South Dakota versus Doe, and how Congress can encourage states to do certain things by attaching it to the money. And the court said as long as it is encouraging the states and not coercing the states, that is then okay. Now, the vaccine issue is something we're definitely going to be confronting in our society, and looking at how that relates to our Constitution and how far can government go in mandating that individuals receive the vaccine. I posed for the students a number of questions for them to think about. One was, could Congress say that states will not get federal funds for education or to support their hospitals if 80% of their citizens do not receive the vaccine? Would that be constitutional? Then I asked them some more questions in my email. What if a state said that unless you get a vaccine, you could not be licensed in that state to practice law? Or what if a state said, unless you get the vaccine, let me go back. What if the federal government said, unless you get the vaccine, you do not qualify to receive federally supported or funded student loans or grants? Can the government go that far in trying to get individuals in encouraging, and some people would say coercing, individuals to receive the vaccine? And what if receiving the vaccine is in violation of certain other rights? So these are all issues that as a nation, we're going to be continuing to think about and to debate about and to try to come to a resolution for us all. We the people. And the preamble of the Constitution says we should pursue justice. And I'm here because I believe learning about these issues and learning about the debates, learning about them, thinking about them for ourselves, that is a key to enlightenment. And enlightenment is a key to establishing justice. And if we don't establish justice all the way, maybe we can have at least a taste of justice. Again, this is a taste of justice with Professor Angela May Kupenda. Subscribe and sign up for notifications so you will not miss a thing. Okay, bye-bye. I gotta get my mouse. Bye.